collection of evidences by the expert till it is delivered in the court. All right. So you need to know what chain of custody is. You may be asked in Viva or even in short notes as well, in a chain of custody. Now, what does it mean? It is a method to verify the actual position of an object from the time it was first identified until it is offered as an evidence in court. Okay, so for example, if a firearm is recovered from crime scene, or if a bullet is recovered from the body while doing autopsy, internal examination, let's suppose that bullet was recovered inside the heart. Right. So as an expert, you have to examine the external examination carefully, internal examination, and then you have to remove the bullet, and then you have to preserve it as an evidence in a container, in a plastic bag or a paper bag, whatever is prescribed. About blood collection, kema garne, trace evidences or kema collect garne to sabai, it's written down. So accordingly, you preserve it, and then you have to hand it over to the police. He will send it for lab investigation. Lab investigation ma pani opinion is drawn out. If the particular bullet is from the particular weapon or not, and then finally it is delivered in a court as an evidence. अब यो त एउटा एक किसिमको chain भयो. You hand over the evidence from one person to another. Now, during this process, it should be well documented. For example, if you have recovered the bullet, you write it down when it was recovered, what was the date, time, and to whom you are handing it over. This way, whoever receives it, he has to document everything. And again, this chain will continue till it is offered as an evidence in court. All right. So this is known to be chain of custody. And why do we need to maintain chain of custody? So that evidences are not damaged, contaminated, or altered. All right. And one thing you should remember is that shorter the chain, better it will be. So that is chain of custody. Now, witness भनेर एउटा terminology छ, term. What do you mean by witness? अब अहिलेसम्म त बुझिसक्यो होला witness भने के हो भनेर. What is witness? If anyone can answer.
Person who gives evidence.
Person who gives evidence. Who gives evidence? Is that Mandeep?
Yes, ma'am.
Mandeep. Okay, good. Who gives evidence? Anyone can give evidence?
जसले त्यो
No, ma'am.
इभेन्ट देखेको हुन्छ.
Okay,
Person related to the person who had seen crime scene or regarding facts.
Okay, so is it necessary that a person कतिवटा type of witness हुन्छ? पहिला actually मलाई त्यो भन त Mandeep. I think I've mentioned it earlier. How many types of witnesses are there?
And two types.
Yeah, right. Kikyo.
One is common and
Huh?
another one.
Another. You as a physician, as a examiner, expert, right? Two types of witness. One is common witness, another is expert witness. And now you have answered that person who has seen the crime on you know, कति अघि मनदीप र अर्को एकजना कसले answer गर्यो. It's not that person who has seen the crime is only the witness, but a person who has perceived by one of his senses. You know, कसैले केही सुनेको मात्र पनि हुन सक्छ. And that can be a witness. All right. अनि अस्ति हामीले evidencesहरुमा direct, indirect भनेको थियौं हैन, hearsay evidence पनि हुन सक्छ भनेर. So a person who has heard from someone else can be also a witness. Okay, so common र expert मा all persons are competent to testify unless they are prevented from understanding the question put to them, or they can't give rational answers to those questions due to tender years, extreme ages, or diseases. You take who can be witness ko answer is this, you know, whoever can testify. All right, but who can testify on that? Those who cannot understand the question cannot testify, who cannot give rational answers cannot testify. It can be due to various reasons, like tender age, young age ma cannot be a witness. Extreme ages ma cannot be a witness. Or if someone is mentally ill, that person cannot be witness. Okay, a person who gives sworn testimony in court of law can be a witness, and these are the criterias. All right, so 3 conditions ma a person cannot be witness due to age, tender age or extreme age, or if someone is suffering from any kind of diseases, who cannot understand the question put towards them or cannot give rational answers. All right, those can be witness. The types of witness, not exactly there are 2 types of witness. One more type of witness is there that is known as hostile witness. I'll make you clear what that means. All right. So common witness, witness of the fact occurrence, witness who gives evidence about the facts observed or perceived by him. You know, whoever has observed the crime being happen or perceived by any of his senses, he must show that he was capable of first perceiving the fact. Okay, मैले सुनेको थिएँ, यस्तो यस्तो आवाज सुनेको थिएँ भन्यो हैन, त्यो भनेर मात्र he cannot be a witness. सुन्नको लागि certain distance सम्म सुनेको हुन सक्छ हैन, त्यो भन्दा बढी नसुन्न सक्ने possibility छ भने he should prove that he was capable of perceiving the fact by one of his senses. That is common witness. Now, who is expert witness? Who can be expert witness?
A person who is well trained in this kind of field.
Okay, very good, Sukriti. So anyone who has skill or is trained and capable of drawing opinion and conclusion from the facts observed by himself or noticed by others. For example, as being an expert, you have not seen the crime being taken place. All right. So you examine the body, you observe what type of injury it was by documenting the type of injury, location, what type of force was used. You document it well, and you can draw out the opinion. Draw out the opinion bhannale, this injury can be a sharp force injury, and a sharp a weapon must be used to produce this kind of injury, you can draw out the opinion and conclusion from the facts observed by himself. If you are examining by yourself, you can draw out the opinion. Or facts others noticed by others. You have written down the type of injury, but someone else, some other expert draws out the opinion. That can be also possible. So these people are trained in these kind of fields. But it's not just forensic pathologist. It can be a firearm expert. It can be a fingerprint expert, handwriting expert. These are few examples of expert witnesses. And various experts are doing so. These are expert witness. Next one is hostile witness. I know hostile witness can be both common as can be expert as well as common witness. One who is supposed to have some interest or motive for concealing a part of a truth, for giving completely a false evidence. I know expert, a common witness bhaera pani auna sakcha, expert witness bhaera pani auna sakcha court ma. All right, but he has some kind of motive to conceal the part of the truth, or he may completely give a false evidence. Those are hostile witness. A motive pani huna sakcha, maybe under threat pani huna sakcha, haina. There can be various reasons, but he is concealing the truth. These are known to be hostile witness. So how many types of witness? There are 3 types of witness: expert, common, and hostile witness. Doctors can be both common and expert witness depending upon the circumstances. Now, recording of evidences. Okay, अब legal procedures मा तिमीहरुको सुरुमा summon दिएर you are called in a court. All right. त्यसपछि after attendance in the court, what are the how evidences are recorded? Okay, so there are various steps for recording the evidences. What do you think the first step of recording the evidence is? Have any one of you gone through the chapter? If yes, then please answer.
म्याम पहिला ओथ लिनुपर्छ कि सबै कुरा ट्रु मात्रै बोल्छु भनेर.
Okay, very good. So first step is the evidence of witness is recorded after taking oath. All right. Oath haneko, I do swear in the name of God. If someone does not believe in God, then they say solemnly affirm that what I shall state shall be the truth, the whole truth, and nothing but the truth. So oath ko a certain line. So maybe you've heard taking oath. Okay, so it shall be the truth, Aniko. Whatever he's giving evidence on should be truth. Truth pani is the truth which is whole, not partial truth. Okay, it should be whole truth and nothing but the truth. Okay, so that is how oath is taken. It holds the witness responsible. Kinada, why do you take oath? What if someone does not give truth or does not give the evidences, whole evidences, then after taking oath, then he or she is responsible for the consequences of his evidences. So if it is proved that you are giving false evidence after taking oath, then you are responsible for the consequences. Responsible for consequences भनेको you might be punished for for giving false evidences. Right? So it is believed that child below 12 years do not require oath because they do not lie. I don't suppose this is true in today's generation, but again, अहिलेसम्म चाहिँ below 12 years मा चाहिँ बच्चाहरूलाई oath लिन लगाउँदैन. All right. So perjury भनेको के हो भन्दा giving willful false evidences while under oath is perjury. So what is perjury भने सोध्यो भने if after taking oath, if one gives willful false evidences, then that's perjury, and witnesses are liable to be prosecuted for perjury, right? Now, after taking oath, there are certain examinations. All right, there are three types of examination. One is examination in chief. Next one is cross-examination. Third one is re-examination. And lastly, there is examination by the judge. Okay, so what do you mean by examination in chief or direct examination? Who does this? First, let's make ourselves clear. Who does this examination in chief or direct examination? It is conducted by the lawyer of the party which has called him. Okay, can someone tell me how many parties are there?
Two parties.
Defense for prosecution दुईटा हुन्छ.
Defense र prosecution दुईटा हुन्छ हैन. Prosecutor lawyer हुन्छ, defense lawyer हुन्छ. For अब कसै कुनै witness चाहिँ defense ले बोलाको हुन्छ, कुनै witness चाहिँ prosecution ले prosecutor lawyer ले बोलाको हुन्छ. All right, so prosecutor lawyer ले बोलाको छ भने चाहिँ first examination जुन prosecutor lawyer ले गर्छ, that becomes examination in chief. And if a defense lawyer does the examination to his own witness, then that is examination in chief. Okay, so first examination कसले गर्यो र जुन पार्टीले बोलाको हुन्छ त्यही पार्टीले गर्ने examination, witnessलाई गर्ने examination is examination in chief. The object is why do you do examination in chief is to elicit the principal salient facts bearing to the case. I know whatever facts is related with the case that is enlightened or elicited in the court. Leading questions are not allowed except in case of hostile witness. Now, what do you mean by leading question? Yes, I want someone else. Then Kritika, Sukriti, दुई तीन जनाले आन्सर गरेछ. अरु कसै सबैजना सुतिरहेछ क्या?
Leading question भनेको चाहिँ त्यो yes no answer दिनुपर्ने टाइपको.
Okay, Sheetal. So whichever question has answer either yes or no, that is regarded as leading questions. For example, was this weapon used? I know weapon dekhaera, was this weapon used? Either it is yes or no. Okay, so examination in chief said this question is not allowed. Kun chai examination ma it's allowed. Vandana, can you answer that?
Cross-examination, ma'am.
Only in cross-examination, very good. So leading questions are not allowed in. But hostile witness भनेको बुझिसक्यो हैन, who has some kind of motive. अब आफ्नै पार्टीले बोलाइराछ, but again the witness gives other evidences, with some motive. So that becomes hostile witness. This much leading question can be asked. Now, next is cross-examination. Cross-examination, where witness is examined by the lawyer of the opposite party. All right, so can you mute yourself? Okay, witness is examined by the lawyer for the opposite party. The lawyer for the accused tries to extract out the witness any fact in favor for defense. I know what are the reasons for cross-examination. Examination done by the opposite party, prosecutor lawyer bolako cha bhane, who examination done by defense lawyer becomes the cross-examination. Now, why do they need cross-examination? So that the whatever witness is giving evidence on, it is in favor of their own case. Afno case ko case like strong banaunako lagi, this cross-examination is done in favor of defense. All right. So they try to extract out of witness any fact in favor for their defense. Purpose for cross-examination is to weaken or destroy the case of the opponent. Of course, they try to weaken each other's case. All right. So cross-examination is done in that purpose. Doctors should be very careful in answering the questions asked in cross-examination. All right. So they can be confused by the other party. Therefore, one should be very careful. And here, leading questions are permissible. There's no time limit for cross-examination. For all other examination, there is time limit, but not in cross-examination. Is that clear? कसैले नबुझेको छ? Let me know. Okay, I take it as you have understood. So the next examination is re-examination. Again, re-examination is done by the previous party who has conducted the examination in chief. That is, who has called the witness, and a party who has called the witness. Now, why do we need to do re-examination? Now, cross-examination ma धेरै examination in chief ma आफ्नो witness लाई strongly present गर्यो. Cross-examination ma there can be discrepancies, so which need to be sorted out. All right. So to clarify any discrepancy arising during cross-examination, this is clarified in re-examination. Here, one thing that you should remember is that no new matter can be added without permission of the judge or counsel, opposite side. All right. Now, again, leading questions are not allowed. And finally, there's question put towards the witness by court or judge. Okay. Now, judge le गर्ने questions, there's no definite time limit. There's no definite step. He can ask question in any time, in any kind of examination. The questions put towards the witness can be relevant, irrelevant, जे पनि हुन सक्छ, and in any form. Normal question हुन सक्छ, leading question हुन सक्छ. So that is question by court or questions examination done by the judge. So here are the five steps of legal procedures. Okay, one is oath, then examination in chief, cross-examination, re-examination, and questions by court. So that is it. Now, next is what are the role of the doctors in investigation of crime scene? Or questions, and how do you conduct in a court as a doctor? Why do you need to know about legal procedures and basic thought is that when you do postmortem or when you do any kind of medical legal examination, you might be called in court for as a witness, as an expert witness. All right. So as an expert witness, if you attend court, how do you behave in the court? How can you help in investigation of crime scene? These are the few things that you need to know right now, right? So as a doctor, how do you help? By examination of dead or living person and by reporting. Examination ma to garer pugeno, you have to document it, give opinion and provide reports. All right. So expert witness in court, after providing report, you have to attend as expert witness and medical opinion necessary for court. Next is conduct of a doctor in court. How do you go to court? Attending court for the first time can be a little bit difficult. Anxious. It's not your area, so you might get anxious. Now, what are the few things that you need to know while attending court? Pandakiri, go to court well prepared with details of a case. Though it's written that examinations are there, but it's not like your written examination or viva examination. Yes, you need to be well prepared, but do not try to memorize anything. It's all there written in the reports, so you need not to memorize it. Be in a position with all relevant certificates, documents, and notes. Whatever evidences you have, you should be ready with those documents. Any certificates required or any notes. Use simple language, avoid technical terms, try to avoid medical terminologies as far as possible. Try to use layman language, which everyone understands, as far as possible. Avoid discrepancies between your earlier statement. Examination in chief ma euta bhanyo, cross examination ma arko bhanyo, feri re-examination ma arko. Don't try to change your statement in every examination. This you will be regarded as hostile witness, or you might be even punished for the act of perjury. All right. So avoid discrepancies. Do not lose temper. That can be very much possible. It's the job of a lawyer to make you lose your temper, and so that his case gets stronger, his or her case gets stronger. So avoid losing temper, always remain calm. And arko euta terms that is known as volunteering of information, which should be avoided as far as possible. Kunai pani information which all right, should be avoided as far as possible. But again, there can be circumstances when you feel that if you don't make that statement, it will result in justice. So in that condition, you should always go for revealing the information. That is known as volunteering of information. And finally, express opinion only on the basis of your knowledge and experience. Don't try to give opinion assuming something else, or whatever is under your area, kati skill, kati knowledge, so tesko barma matra you can give opinion, not beyond that. All right, or experience. Okay, that is the role of doctor in the court. Now, next is court system in Nepal. Nepal court system, district court first court for all cases can be civil and criminal, except in women trafficking and Civil Aviation Act, hijacking and passport. Isko lagi chai yo bahek or sabai first cases is done in district court or contempt of court. And next is appellate court, appeal from the district court. Ani kun cases ko like first court ho banda kheri, it's for complex cases from अख्तियारको केसेसहरू पनि हुन सक्छ हैन अथोरिटी अब्युज इन्भेस्टिगेसन कमिसन राइट एप्लिकेसन म्याडिसमस र इन्जङ्सन यो केसेसहरूमा चाहिँ सुरुमै एपेलेट कोर्टमा जान्छ अदरवाइज any complex cases from district court goes to appellate court. And finally, there is Supreme Court, appeal from the appellate court, contempt of court, right application, trial from the cases of CIA and precedent. Theo cases also, it goes to Supreme Court. Punishment, I don't have to repeat again, it's already done. So these are the various type of court. Now, things to do, I want you to remember, I want you to find out how many courts are there in our country. कतिवटा district court छ, कतिवटा appellate court छ, अथवा Supreme Court कतिवटा छ के छ. Now, please find it out by yourself. And more next class, I'll be asking you that. All right, so that is it about legal procedures. Now, there's still time remaining. So, action log out, log in, and we'll start with injury.